Good morning. Welcome, everybody. Welcome back, I should say, to everybody. I think everybody might be aware, I'm Matt Pinsker. I'm the history professor here on campus, and I hold the Brian Pohanka Chair for Civil War History. He was class of 1977, so I think some of you in this room remember him well. I got a chance to meet with him, and I can tell you that one of the reasons I'm here today is because his family has been so generous in endowing the program that I run here on campus called the House Divided Project, which is a multimedia initiative, students and teachers and staff working together to try to create resources to use 21st century technology to engage mostly high school students in the study of the 19th century, especially the Civil War era in American history. And that's why this presentation is so important for me. Judge Logue will be here in a minute to talk about how the Civil War shaped the modern Constitution. And this is now the 150th anniversary of Reconstruction, what historians are starting to call, or have been calling, the Second Founding. This is a very important topic. Some of us believe the Constitution was reshaped more during this era than it was shaped during the founding era, especially as it relates to modern day social controversies. And that's what we're going to hear about today. But I wanted to make sure you were aware that this presentation is going to be part of our YouTube channel now. At the House Divided Project, we have a YouTube channel that broadcasts interviews and lectures and documentary shorts. We have nearly 1 million views now on our different programming, mostly educational from the Civil War era, and this will be our latest offering coming soon this summer, so I'm very excited about it. If you came early enough, we had handouts about the project. We're doing all kinds of things with new technologies like augmented reality. This is a program that we use from Hewlett-Packard. It's free. It's image recognition augmented reality. So when we have exhibits in our studio, which is now brand new and open on 61 Northwest Street, you can point a tablet or a phone at the picture of Abraham Lincoln or Dred Scott or the Civil War era illustration that we have featured, and it will trigger a video about it or web content. And what's great about that from where I sit is that all of those exhibits that we've created with our students are downloadable as PDFs and can be put up in teachers' classrooms anywhere in the country. Today, I just got an email this morning from a teacher in California who had worked with us here. We've trained over 5,000 educators from across the country. And she had introduced her students to Erasma, this program from Hewlett-Packard, and they had done their own augmented reality exhibits based on our model. And one of the students, without realizing the connection, had taken one of my video clips from the History Channel and augmented one of her pictures in her report, and the teacher from California was sharing it with me. So sometimes the internet is good for connecting good people together to do good work. It's not always about rising hostility. And so that's what I hope this session this morning will do for us as well, a chance to share important ideas about an important subject with a wide array of lifelong learners and educators. All right, so with that framework in mind, I want to introduce Judge Thomas Logue. He is our guest today, a member of the class of 1977, an English major. So just proves they can get employed as well. Judge Logue was a practicing attorney for 30 years in Florida. He taught constitutional law in Florida at several law schools, and now he sits as a judge on the Court of Appeal for Florida in the 3rd District based in Miami. He has an extraordinary legal career, but he's here today to talk about how the Civil War shaped the modern Constitution. He's done an extraordinary amount of work and thought and reflection about this topic. We're very grateful to have him. And I should also point out, as an aside, for those of you in the room from the class of 1977, he told me that he met his wife Sheila here at Dickinson College, who was also a member. Story of race, rights, power, and love as well. It's got all the dimensions of a Hollywood movie. So, Judge Logue, please take the podium. Let's give him a warm welcome.
Professor Pinsky, thank you for that introduction. Like a lot of alumni, we're really excited with what you're doing with the House Divided project. I am so excited to be talking to this group about this topic because really it was 40 years ago, talking with my classmates and the professors here and Brian Pohanka, that I began to get interested in the Civil War. So here's 40 years of my thinking about this topic. When someone says the United States Constitution, what do you think of? Well, if you're like most people, you probably think of cases that deal with the right to choose, or the right for adults to buy birth control, or the famous Miranda warning, you have a right to remain silent, that we see so much on TV. Or maybe the right of a poor person to be assigned counsel if they're accused of a crime. Or maybe even just the broad principle of equality before the law. Well, all these cases were decided under the 14th Amendment, which we'll talk about, which was enacted as a direct result of the Civil War. So when most people think of the Constitution today, they're actually thinking of the post-Civil War Constitution. What we're going to talk about today, Brown, or the right to choose. I'm sorry, I missed that case. What we're going to talk about today is that the Civil War was a constitutional crisis. It expanded the constitutional powers of Congress. Also as a result of the war, the constitutional powers of the president were expanded. For the first time in our country, really, we created a regime of federal constitutional rights against the states. And as a result of the Civil War, we really redefined the idea of we the people. So, and at every point, I think you'll see the African American experience was actually central to this constitutional change. Okay, the Civil War, the worst war in our history. You can take all the dead from World War I, World War II, Vietnam, Afghanistan. It would not add up to the number of American soldiers killed in the Civil War. What caused the Civil War? Well, slavery was clearly a necessary, if not sufficient, condition. We often, can everyone hear me? You know, when I was studying this, the view was African Americans were pretty passive in causing the Civil War or involved in the Civil War. A lot of modern scholarship is indicating, no, it was African Americans who helped raise the issues that led to the Civil War. African Americans, for decades before the war, escaping into the North created a tremendous amount of friction between the North and the South, leading to, in 1850, the adoption of a very draconian fugitive slave law that basically said a person in the North could be arrested and transported south based upon affidavits. Northern states responded with personal liberty laws insisting, no, there has to be a jury trial before like an allegedly escaped slave was returned. And of course, northern juries would not return people. So the Southerners were like, well, that's, dishonest. We all know about Frederick Douglass, but actually Douglass was only one of the many African-American abolitionists advocating for, the abolition of slavery. There were newspaper editors, there were escaped slaves writing books. Now you might see the movie, it's a movie now, 12 Years a Slave, Northrop Solomon's 1853 book, which was a bestseller at the time. A freed slave who was actually arrested and taken south mistakenly. A freed person who was never a slave. And of course, you've all heard of Dred Scott. Well, we're now seeing with the scholarship that it wasn't just Dred Scott who brought a lawsuit, but there were thousands of African Americans bringing lawsuits in the courts about their freedom. Many of them were very successful, and these percolated up to the highest courts in the states, and there were about 6 or 7 cases in the United States Supreme Court, all very heated, all very controversial. Which brings us to our first point. The Dred Scott case helped trigger the war, and we'll talk a little bit about that. But when I would read about the Civil War, the blue and the gray, and I'm very interested in the history of the military history of the war, but I didn't realize what an incredible constitutional crisis it really was. preamble of the Constitution says the purpose was to create a more perfect union. Well, the purpose of secession was to destroy that union, or certainly separate the union. Which brings us to the president at the time of secession, Dickinson Class of 1809, one of us, perhaps the worst president in American history. He said, look, secession is unconstitutional, but I have, but anyway, a crisis. The end of what the Constitution was created. But the constitutional crisis wasn't just that, because in the tension of fighting the war and winning the war, and in the tension of reconstructing the country afterwards, there was basically a civil war between Congress, the president, and the courts. And we don't want to talk about this too much, but let's put it out on the table. Here's Andrew Johnson, became president when Lincoln was assassinated. Johnson was from Tennessee, a Democrat. Lincoln had him as part of a Union ticket to win the war. Johnson gets in. Johnson hated the planter class. But he really identified with poor whites, which was a class that he came out of. Apparently, his wife taught him how to read when he was 25. I had kind of a similar experience. but Johnson was also extremely prejudiced against African Americans and felt that anything that elevated them was basically destroying the poor white class. Johnson, in his relatively short tenure, had 29 vetoes of major bills. 15 of those vetoes were overridden. And one of those vetoes was overridden by both houses on the same day that it was signed. So you can see the tension between Congress and the president, getting higher and higher. Of course, you all know that led to Johnson's impeachment. What you probably might not remember is that historians tell us that while the impeachment was going on, the Republican Congress, the radical Republican Congress, came up with the idea of, look, if we've impeached someone, they should be removed from office until the trial's over. So they were discussing this. At that point, President Johnson, President of the United States, went to the very popular and powerful U.S. Grant, who was the head of the armies, and said, look, if these wackos pass this law, who are the armies going to back? Are they going to back me, or are they going to back Congress? That's a constitutional crisis. That's not all. There was also a battle with the courts. You've all heard of Roosevelt's plan to pack the courts. He didn't succeed. Wasn't that a horrible thing? Actually, during this era, they did pack the courts. Lincoln and the Congress. Admittedly, they were dealing with the Dred Scott Supreme Court. But during Lincoln's tenure, the number of justices went to 10. When Johnson got in, Congress shortly afterwards reduced the number of justices to 7 to make sure Johnson did not have an appointment. And then when reliable Republican Grant gets in, they put it up to 9. Not only that, Congress stripped the jurisdiction of the Supreme Court at least one crucial moment to stop the Supreme Court from looking at a particular case. People today talk about, we're in a time of great division and everything. It's Hollywood Squares compared to what was going on. In the course of this, we have the constitutional expansion of Congress's constitutional powers. So, and I'll just give you a couple examples. So the Constitution says Congress has the power to coin money. Does that give Congress the power to issue dollars, legal tender? Now, the government had been issuing bonds which bore interest. And you could accept or reject those bonds. But legal tender means this paper is actually legally satisfies a debt. I could owe you $30 in gold, and now I can pay you $30 in paper, even though everyone understood the paper will inflate. I jumped ahead. Actually, does it include legal tender? Well, in 1862, for the first time in our history, the federal government issued dollars in the form of legal tender. Not interest-bearing, and you had to accept them. This put the federal government, and they understood at the time, in the position of controlling the money supply. At the same time, they taxed out of existence what were state currencies. So now the federal government was in the business. They understood, you expand the money supply, it heats up the economy. You shrink it, it slows it down. So now you had the federal government managing a national economy based upon this power. It was challenged in the Supreme Court. It was initially held to be unconstitutional, but on rehearing, after Grant appointed his two people, miracle of miracles, it was upheld 5-4. Again, we're so used to this, it's hard for us to think about what a revolution this was. Here's another one. Constitution says, hey, Congress can raise armies. Can they draft young men and force them to serve in the armies? Before the Civil War, for example, when Washington was raising troops for the Whiskey Rebellion and ordering them to marshal here in Carlisle, he sent proclamations to the states saying, I'm calling out your militias. He didn't draft troops. At the beginning of the Civil War, Lincoln did the same thing. He sent out proclamations to the states. I don't know the numbers, but New York, I need 25,000 from you. Little Delaware, I need 2,000 from you. Does this power give the power to draft? It was never viewed that way before, but of course, during the Civil War, we had the first draft in our history. This was ultimately challenged in the courts and ultimately upheld. We also have the beginning of the administrative state that we know so well. The Internal Revenue Service was created. We have the first income tax. By the way, that was challenged in the courts around the era of World War I, declared unconstitutional. The Constitution was amended. But it's the Internal Revenue Service. I always wonder, what does that mean, internal revenue? Well, to a large degree, the revenue of the United States federal government was based upon tariffs, mostly paid by the state, by the South. But so they created an internal revenue because for the first time, the federal government was getting involved in massively taxing inside the United States. The Justice Department, as we know it, there'd always been an attorney general, but he didn't have a battery of lawyers. The Freedmen's Bureau, for the first time, the United States government got involved in social services. Why is the creation of departments constitutional? Well, there was a big debate going on in our country from the beginning, could the federal government get involved in social services? It goes back to the debate between, and these other matters, it goes back to the debate between, Hamilton and Jefferson, and you can see it in the vetoes of Jackson, Pierce, Tyler, where they vetoed a bunch of internal improvements saying, hey, the federal government doesn't have any power to do internal improvements. But here, after this Civil War, the Whig side wins that, the Western frontier idea, folks that really wanted the federal government involved in improvements, kind of win that debate. And that debate's kind of over. So, expansion of congressional power. We also have the expansion of presidential power. Lincoln invented the expression war powers. I mean, he came out and said, and I think he's right, really, and even today in the War on Terror, people go back to they look to the Lincoln administration for precedents. And Lincoln said, look, there are things that a president can do in wartime that are constitutional, and even though they'd be unconstitutional in peacetime. And in fact, one scholar has come out and said, if you think about the constitutional decisions that were made in this era, the two most important constitutional interpretations were not made by the courts, they were made by Lincoln. So the first of those dealt with the decision to combat secession. Here again, class of 1809, our guy. Good man, but in very difficult circumstances. He was like, secession is illegal, but the federal government doesn't have any delegated powers to fight secession. So the guy from Illinois is like, no. Immediately threw the federal government in on the side of preventing secession. Congress was not in session during the first 4 months of the Lincoln administration. I think it couldn't even sit because some of them had been elected, their terms weren't even going to begin. Without Congress sitting, Lincoln went ahead and said, no, we're going to combat this. The second major decision, constitutional interpretation, dealt with slavery. Here's President Buchanan. Listen, you know, the federal government has no power to interfere with slavery in the states. What the heck on earth was he talking about? Well, the original Constitution protected slavery. You know, it was drafted by, you know, colonial Enlightenment folks. They were children of the Enlightenment. They did not use the evil term slavery, but they protected slavery at several points in the original Constitution. For example, this is the fugitive slave provision. More than that, slavery was kind of like a super property under the original Constitution. It was the only property that was specifically identified for protection. And also there was the Three-Fifths Clause. Now we sometimes say, well, the Three-Fifths Clause, it's bad because it means African Americans were counted as 3/5 of a person. In some ways it's kind of worse than that. What it really meant is that voting districts in the South, people who owned slaves would get an extra 3/5 vote for every slave they owned. In other words, certainly the districts where they existed. This increased the South's voting power. And in fact, there's scholarship now that indicates Jefferson would not have beaten Adams but for this little boost that the Constitution provided. I'm a huge fan of Thomas Jefferson. I'm not passing any value judgments, but this was the Constitution protected slavery. Which brings us to the Emancipation Proclamation. The second biggest interpretation that really shaped our country and really our Constitution. So Lincoln accepted, I can do nothing with slavery in the states. The Constitution is very clear. He ran on a platform that overturned Dred Scott and to prevent slavery from going into the territories, where everyone knew that was where the population was going to move in, all the new states. Hey, the slave states are already outnumbered. They will be super outnumbered within 20, 30 years, as long as we keep slavery out. People now criticize, well, Lincoln was an abolitionist. No, he wasn't, but he also wanted to put slavery on the road to extinction. The South understood exactly what Lincoln was doing. In fact, they went to war over it. But the Emancipation Proclamation, Lincoln says, slavery is protected, but we're now at war. As president, I can seize the enemy's horses and cannons and corn and forts and ships. Well, I can also seize this property in human beings. So he says, every slave in the states in rebellion will be freed. Remember, too, there were slave states that stayed in the Union. This did not apply to them. Revolutionary. And the second half of the Emancipation Proclamation was just as important, and we forget about that, because he said, and we will start recruiting and training newly freed people to serve in the armed forces. In the course of the war, the Union fielded about 2 million people in the course of the 5 years, 2 million soldiers. By the end of the war, around 200,000 or 10% were African Americans, way in excess of their population in the North. And about 25 African Americans won the Medal of Honor during the war. So with the Emancipation Proclamation, Lincoln said, he changed the war aims. Instead of returning to the Union as it was, it's now we're going to have the Union, but it's going to be a little different than what it was. So expansion of the war powers. Here's another matter. We take this so much for granted. It's a little hard to wrap our heads around it, but there were very little powers, rights in the Constitution that limited the states, like the contract clause did, but really, we now see for the first time the regime of federal rights against the states that we just take for granted. And this brings us to the trilogy of constitutional amendments that resulted from the Civil War and the immediate aftermath of the Civil War. 13th Amendment ended slavery, greatest act of liberation in our country. By the way, setting aside the morality of owning property and human beings, the greatest taking of property in our history. You know, in the South, the thing that had the highest value was land. After that was slaves. So it's estimated maybe $1 billion of property in dollars, their dollars, was taken. Of course, the last of the trilogy was the 15th Amendment giving African Americans the right to vote. Again, amazing change in our constitutional trajectory. But in some ways, for most people, and I think, by the way, we don't talk about the 13th and 14th Amendment as much as we really should, but for people living today, the most revolutionary was the 14th Amendment. Why? Well, the original Bill of Rights applied only against the federal government. It did not apply against the states. So, for example, states could interfere with your rights to free speech. They could establish religions. If you lived in Virginia, you would pay, in the decades after the adoption of the original Constitution, you would pay taxes to support the Episcopalian Church. If you lived in Massachusetts, you would pay taxes to support the Congregational Church. So, for example, let's look at the First Amendment, the magnificent first sentence of the First Amendment to the Bill of Rights. Amendment 1. What is the level of government that's viewed as the threat to liberty here? And what is the level of government that needs to be restricted? Well, it's the federal government, not the states. Let's look at the 14th Amendment, adopted in 1868. This is the great due process clause of the 14th Amendment, probably the most litigated constitutional provision in our history. What is the level of government that's viewed as a threat to liberty here? And what is the level of government being restricted? It's the states. Now, what's due process? Due process, ultimately, what are the rights being protected? Ultimately, there's a development in the case law which indicates, really, a lot of those things are what is expressed in the Bill of Rights. So we have the Bill of Rights incorporated into the 14th Amendment to now apply against the states. So, the Founders' Bill of Rights policed the federal government to protect state and local communities. I had a hard time wrapping my head around this when I first was exposed to the idea. But if you read the original Bill of Rights and forget about the lens of the post-Civil War amendments, because we look at them through the lens of the post-Civil War amendments, but if you go back and read the original Bill of Rights, they're really an affirmation of federalism. They're really an affirmation of state rights. You can see that in the Second Amendment, which says, hey, federal government, you can't stop us from you can't stop states or local communities from creating militias. You see it in the Establishment Clause, right? Which really what it says is, it's the state saying, hey, federal government, we're creating you, but you are out of the business of establishing religions. We reserve to ourselves the decision whether or not to establish religions, and in fact, some of them did. You see it, in the prohibition against general warrants. Hey, federal government, central government, you want to search people. Okay, sometimes you have to have searches. It's got to be based upon specific facts relating to that specific property you want to search, and a local magistrate's got to sign off on it. You really see it in the jury trial. So, if you read the jury provisions, forgetting about the subsequent history, really what the Bill of Rights was saying is, okay, federal government, we the people, we the states are creating you. You can have laws, you can prosecute people. But if you're going to prosecute people, you're going to prosecute them in the locality where the alleged crime occurred. You're not shipping them off to London, which is what England did, and you're not shipping them off to Washington, D.C. You're going to prosecute them in the local place. By the way, and you're not going forward with your federal prosecutor, your central government prosecutor filing charges. Oh no. you got to get an indictment from a local grand jury. And even then, when you want to establish the facts on which the prosecution is based, you have to go in front of a local petite jury, and they have to find the facts. So there's a lot of scholarship now suggesting this is really an affirmation of federalism, states' rights. The post-Civil War Bill of Rights really adds something new. It polices the states to protect individuals. So the idea here now is like, you can think of I think they were thinking of the newly freed African American who had to deal with Southern government, Southern sheriffs, and yes, even Southern juries. So our views of the relationship of judges and juries changed about this time as well. Another revolution in terms of rights that occurred as a result of the Civil War. Whenever I think of American rights and liberties, the first thing that comes to my mind is equality before the law. And those unbelievably inspiring words by Jefferson, and that the founders adopted. We hold these truths to be self-evident. All men are created equal. They're endowed by their Creator with certain unalienable rights. Okay, created equal. Well, before the Civil War, equality did not appear in the Constitution or the Bill of Rights. You can read the text of the Constitution and the text of the Bill of Rights. You will not see any reference to equality. Equality only appears now in the 14th Amendment for the first time as part of our organic law. Why was equal protection left out? In light of its centrality to the Declaration of Independence, we'll deal with African Americans. Why was it put in 1868? To deal with African Americans. Again, the centrality of the African American experience. Many people have gone on to benefit from this, other than African Americans, but the African American experience was central to this constitutional change. We also see the intergenerational nature of our constitutional change, because we kind of started out with the Declaration of Independence. All people are created equal. And then we departed from that. And here we're circling around back to where we began, equal protection, but at a higher level. And we're really seeing, think of the words of Lincoln in the Gettysburg Address, of a nation conceived in liberty and dedicated to the proposition that all men are created equal. That's Lincoln, and he's really reinterpreting Jefferson to raise that to the central part of our constitutional enterprise. So equal protection in this new regime of rights. That's why, as Professor Pinsker referred to, this era is modern scholarship is saying, look, new birth of freedom, second founding, really. Regarding the trilogy, the great trilogy of Civil War amendments, the 13th, 14th, and 15th amendments, there's another thing I just want to touch on, which, again, we always overlook. These amendments, we talked earlier about how there was a reinterpretation of the Constitution to expand the powers of the federal government, mainly to win the war and deal with the crisis of Reconstruction. Well, here in these amendments, you basically have a ratification of that expansion of the power of federal government. I mean, one of the things that always amazed me when I first started reading in this area 40 years ago was you'd read the founding documents and it's like they viewed the states as the source of freedom and liberty, and they viewed the central government as a huge danger. The federal government only has limited enumerated powers, and I'd look around and go, wow, I mean, the federal government's it's a pretty big footprint. And then it was like, well, is this a conspiracy? How did this happen? Well, actually, it happened due to a bunch of results. But here we have, in the 13th Amendment, part of that process, because we're going to end slavery. Well, who's going to enforce this? Will it be the states, or will it be the federal government? Now, it's going to be the federal government. It's an expansion. It's a constitutional expansion of the power of the federal government in this area. Same thing, the 14th. Who's going to enforce the new rights to equal protection and due process? 15th, who's going to enforce the rights of African American males to vote? Well, is it going to be the states? No, it's going to be the federal government. And this then creates a pattern that runs through the rest of our constitutional development. So the first 10 amendments, the Bill of Rights, limited the power of the federal government, as did the 11th Amendment, limited the power of the federal courts. Starting with the 13th Amendment, almost every amendment of the next 14th Amendments expands the power of the federal government. So, for example, I'm not going to run through them all, but for example, the 26th Amendment, right of 18-year-olds to vote. Who's going to enforce this? The federal government's power will be expanded to enforce this. Which brings me to my last section. The Civil War also redefined the constitutional expression, we the people. In this regard, before the Civil War, a lot of people had a lot of Americans had a very narrow, crabbed view of who was a citizen. And probably the most authoritative expression of this idea was made by Chief Justice Taney, Dickinson Class, 1797, I believe. And the Dred Scott case also had another graduate of Dickinson on the court at that time. So Taney, in the Dred Scott case, Taney in the Supreme Court held, listen, African Americans, they're not citizens. The states cannot make them citizens, and even Congress cannot make them citizens. Why? Because the Constitution draws a line between the citizen race, who formed and held the government, and the African race. Regarding the citizen race, the Constitution was formed by them and for them and their posterity, and for no one else. And folks, I think there are people in the United States who still think this way. But here's the wonderful part. In 1868, with the adoption of the 14th Amendment, the people of the United States, not the president, not the courts, not the professors, the people of the United States amended their Constitution to reject this view. The first sentence of the 14th Amendment creates birthright citizenship. No. You're born in this country, you're a citizen of the United States, and you're a citizen of the state you reside in. This debate is over. Again, many ethnic groups have benefited from this, but this was put into the Constitution to deal with the status of African Americans, showing their centrality to this process. So, you want to talk about American exceptionalism. This view of citizenship, birthright citizenship, no country in Europe has this. In the United States, it doesn't matter who your parents were, doesn't matter their race, doesn't matter their religion, doesn't matter their ethnicity. There are no subclasses, there are no untouchables in our system of government. To be a good American, you don't have to be of good British stock or good French stock or good German stock. You just need to subscribe to certain ideals, those expressed in our Constitution and our founding documents and the post-Civil War Constitution. So if this is your view of the United States, and by God, it's my view of the United States, this is a post-Civil War view of the United States. Listen, as I am now wrapping this up, I just want to acknowledge some of the incredible scholarship that's taken place in this area. One of the greatest legal scholars in our living legal scholars and legal historians is a professor out of Yale University. If you're interested in this topic, strongly encourage you to pick up one of his books. So, what is the signature case of American constitutional jurisprudence? I think most people would say Brown versus Board of Education. I think what I believe, in light of the facts we've been talking about, it's absolutely no coincidence that that case involved African Americans. And it's no coincidence that the lawyer who won that case was African American. It was won by Thurgood Marshall, who then became the first African-American justice of the United States Supreme Court. Marshall probably thought about what we're talking about more deeply, more profoundly, in scarier circumstances where he was putting his life on the line more than any other American. So I'd like to end on his words. He said, while the Union survived the Civil War, the Constitution did not. You might not agree with everything Justice Marshall says in this regard, but I hope you agree with me that the Civil War shaped the modern American Constitution. Thank you very much.
Everybody agrees. It's a fascinating subject, and that was an excellent presentation. I know Judge Logue is happy to take questions or comments, so feel free to ask them. And I'll stand up here as well if anybody wants to ask anything about the House Divided project, but I'll turn over the microphone to the judge. Rachel is walking around with a handheld microphone, so before you start to ask your question, make sure you have the microphone, because we are recording this on YouTube.
Thank you, Judge, for a wonderful presentation. Very often when Supreme Court justices are identified as originalists, does that mean that their concept of the Constitution is prior to the Civil War?
That is a great question. And I think, pardon me? The question was, when some people talk about original intent of the Constitution and interpreting the Constitution based on the original intent, don't they mainly focus on the 1790 Constitution? And are they considering these ramifications? And I think that raises a very, very good question because, and I can't speak for other people, but you know, when you talk about original intent, which I think, by the way, is a very powerful idea, I am not in any way dismissive of that, but you see the complexity of it because let's say, for example, the First Amendment. What does the First Amendment mean? Does it mean what the original founders viewed it as? Who, again, we're looking at as kind of a statement of federalism, or does it mean what the drafters of the 14th Amendment were thinking of when they said, we want this to apply to the states? So it does become complex, the idea of original intent. But, you know, my own take on that whole thing, I mean, there's a big discussion about, and big dispute about, you know, how do you interpret legal documents, how do you interpret the Constitution? Should it be based upon original intent? Or should it be based upon the text? Or should it be based upon the living Constitution? And I've thought a lot about that, and I know the right answer. And the answer is yes. I just think anyone who says like there's one silver bullet for interpreting the Constitution, I think is being a little simplistic. We certainly have instances where any of those approaches do not lead to the correct result. So I say of judging, it's kind of like singing. Some people are good at it, some people aren't. You know, the best the judge can do is just try to educate themselves in the tradition and try to be loyal to it. I just don't think there's one silver bullet.
Thank you.
Thank you for the very inspiring and informative presentation. You spoke a lot about the past. I was be interested to hear about the current situation and the future, your thoughts and reflections, and what guardrails are in place to protect what so many people work so hard to put in place.
And let's see if you could say something that might generate a presidential tweet.
You want to take that question? I don't want to touch that without
okay, so I'll bail you out. But, you know, obviously it has immense ramifications for how you interpret the Constitution today. One of the things I've learned as a history professor, I'm no judge and I'm no lawyer, but as a history professor, I know that even if you exclude the Civil War era Constitution and just focus on the founders and their Constitution, they argued over their own intent, and some of their intentions changed in the course of the summer of 1787 when they were debating the framing document itself. So originalism is, I think it's a simplistic notion, and that also means it's a bracing reminder for us today, which is these are complex issues. People's views are going to change. We should be, modest about our certainty. I think that's the point the judge was just making. Modesty and humility in the face of, what are really very complicated, challenging things. So in our current day, I mean, we all have heated political opinions, but we should keep trying to remind ourselves that there is no simple answer to some of these questions, whether you're talking about the travel ban or other issues. And, we have to give our opponents some latitude to work out positions. Because in the past, as the judge said so eloquently, their conflicts, whether it was 1787 or 1863, they made our conflicts look like Hollywood squares, as he put it.
Good morning. You talk about how the evolution of states' rights happened as a result of the Civil War. Can you speak a little bit about what happened to tribal nations' rights during this period? Because they were framed in the Constitution as sovereigns. We had treaties with them to help during the Revolutionary War, during the War of 1812, and then Andrew Jackson changed that. And then you have issues like the Cherokee Nation's freemen issues, where slaves were made as members of the Cherokee tribe by the U.S. government, in essence, as punishment for their siding in the Civil War. Can you speak a little bit about the evolution of the treatment of tribes during this period?
What a great question. I am not particularly knowledgeable about that, so what I used to do in class was... And that is an awesome, and I need to read more about that. And I think the status of the Indians is very, or the Native Americans is very interesting in our Constitution. I mean, originally, even slaves were counted, went into 3/5 of the legislative process, but untaxed Indians weren't even counted. But
yeah, so in the Reconstruction era, they used a phrase in the civil rights legislation and in the 14th Amendment that was designed to exclude Indians from the consideration of these clauses like due process and equal protection. That was subject to the jurisdiction thereof. That was a phrase they used to apply to different groups of people, but one of them, according to the legislative debates, were Indians. And that was because they're living in that post sort of Jackson-Marshall battle over how to define Indians, and that was the sort of suspended state of the Indian nations at this time. They weren't sovereign, and they weren't totally incorporated into the idea of citizenship. Then at the end of the 19th century, there was a new Supreme Court approach to this. This is embodied by something known as the Lone Wolf v. Hitchcock decision, 1890s. Part of it was inspired by some of the experiences of Indians at the Carlisle Indian School in terms of fighting for assimilation. They ended up defining Indians as subject to the rule of Congress entirely. And Congress then ultimately decided in the 1920s to incorporate them as full citizens and apply the 14th Amendment to them. That's how it evolved.
But I'm going to read more about that. Thank you for bringing that up.
One of the, just looping back real quickly to the originalist or that type of thing, one of the ways that many different documents, many different traditions are interpreted, I'm thinking in terms right now of scriptural interpretation, where you're trying to put yourself in in the person of a 5,000 years ago Palestinian or a first century Hebrew. Is there any validity to trying to reframe yourself as an educated white slaveholder from the 1700s, or is that really not where you would want to place yourself as you're interpreting what they were thinking?
Well, I've ducked two controversial ones, but I'm not going to duck that. I think that's a very interesting question. I think we have to be careful about just facing the truth. And part of the truth is facing the horrors of slavery and facing our countries and our governments at different levels involvement in that. But also these people who held slaves, they were also very jealous of their own liberty. And they came up with ideas that are very protective of liberty. And I think you can't, look at Jefferson or whatever. So those ideas are powerful. I mean, they're rocket fuel. And I am not one to be too dismissive. So I think, yeah, to a certain extent, we need to look at that. I kind of view it, if they made a mistake, is that they weren't expanding these ideas to a broad enough group. But on the other hand, they started the process of, they themselves radically expanded the rights when they said white males who own property are part of the government. Everywhere else in the world, you had kings and princes. And so they really not only created these ideas of how to protect liberty by separate branches of government, federalism, et cetera, but they also introduced the idea of, we need to, not only that, these rights need to be expanded to a bigger group of people. And in a sense, our American constitutional history is taking their lesson, but taking it further than they could see to expanding these rights to a broader and broader group. So I would share that. And also, I think in some groups there's a tendency, we're dividing into tribes. And I sometimes go to the meetings of the different tribes. And, so one tribe, will laugh at a living constitution idea. And then there's another tribe that's like, living constitution, obviously, that's the only way to interpret the Constitution. And you got to be careful with that, too. I mean, think of this circumstances. We have a living constitution. We're in a time of terrorism. Terrorists could get a hold of a hydrogen bomb. This whole idea, the Constitution says juries, right? But back then, juries were only white males. They excluded African Americans. They excluded women, So we're going to have a living constitution, and you don't even have to be educated to be served on a jury. So we're going to have a living constitution in a time of terrorism. We're going to have juries, but they're all going to be college educated. They're going to go to West Point. We're going to have military tribunals instead of juries. And I think, and this is the living, it wasn't what they thought in 1790, but, it's a living constitution. And I think most people would say, hell no. The original intent of juries would be the jury of the peers, the jury of citizens. So I wouldn't, living constitutionalism is not a silver bullet either. I would suggest, just like originalism, we know in certain circumstances doesn't get us where we need to get to. Textualism doesn't necessarily get us where we need to get to. I mean, look at, the First Amendment, Congress shall make no law establishing religion. Well, what if the president says, okay, that limits Congress, but I'm going to say everybody in the armed forces has got to be Episcopalian, only during the war, or has to take Episcopalian communion, because we need to be together for this war. And I think the text says it only limits Congress. So theoretically, if you're a pure textualist, expression of one thing is exclusion of other, doesn't limit the president. So my concern is everybody wants to have the silver bullet, the one, I would say Germanic, but anyways, the one European first principle that can be applied everywhere. Well, a lot of our tradition is pragmatism. And you've got to be careful, but I don't know if I answered your question. No?
Thank you for an elegant and enlightening presentation. It was just fabulous. I was wondering if you could shed any light on the inclusion of the language in the 13th Amendment that says neither slavery nor involuntary servitude except as a punishment for a crime where the individual's been convicted. And many of us have seen Anna Duvernay's incredible film, 13th, and that this is seen as opening the door to, all right, you can incarcerate. And this led to the incarceration of freed slaves immediately and in Reconstruction, and as even talked about now as a source of the problem. So how was that language included, and what was the context? And if you have any thoughts on that, I'd love to know.
I have to be honest, I am not, I'm not sure I'm qualified to, I want to hand it to you, but let me just as a little background, I'll give you a minute. This is another hard one, so you know what I do with hard ones. But, there is, if you haven't heard about it, there's an issue out there that, we have private prisons. So in some of the, and I actually think it's a perfectly legitimate idea that if you have a prisoner in prison, it's actually very healthy for them, I think, to help, to do work. And actually, I visited prisons where the waiting list to get on the work things was 10 years long. And the least demerit, and you were knocked off. But that being said, there are private prisons that are functioning as for-profit commercial manufacturing enterprises, and they are using the prisoner labor to do this. So the question becomes, whoa, I mean, at some point, is this it's starting to look like slavery? And some of those people are being held, haven't been convicted yet. But anyway, with that little background, let me give the hard part to the Professor Pinsky.
So the wording for the 13th Amendment is actually taken from the Northwest Ordinance, which was the second most important thing that happened in the summer of 1787. When they were framing the Constitution in Philadelphia, the Confederation Congress was adopting a Northwest Ordinance that banned slavery in the territories that became later states like Ohio and Illinois. And they used that language in order to avoid challenges to the penal system. And then when they were debating the language for the 13th Amendment, they had a variety of options. They argued pretty bitterly over it, and they settled on a return to 1787 as a way to, reframe what the Republicans thought was the real intent of the Constitution, which was to stop the federal government from abolishing slavery, but allowing the states to do it. And so they felt like that was a good symmetry. Of course, as you pointed out, what happened in the years, not immediately after the ratification of the 13th Amendment, but in the decades after, Southern states, once they regained power, they began to use criminal laws to create a new form of servitude, a kind of return to slavery. And so that became the next great challenge of the Jim Crow era, was fighting the question of the carceral state, is what we call it now. It's what that documentary is about. If you haven't seen it, it's a powerful one. It's a lingering issue for today, for sure, which is, do we use prisons today the way Reconstructed Southern states used them in the Jim Crow era? And that's a tough question, but it's an important one. All right, maybe one more question for the judge? Just wait for Rachel to bring the microphone around.
Thank you again. This is great. I'm interested because Lincoln made, and I learned this because of Professor Pinsker's class.
Yeah, former student.
One of the things we forget is that the Civil War technically wasn't a declared war. It was a suppressing an insurrection because we didn't recognize the Confederate States as a separate country. They were always Lincoln's like, no, they're not. They're always the United States. They continue to be. And I think the issue, what's interesting though, is the issue of West Virginia, because in theory, though, if you still recognize the states, now granted they had a bump government, a parallel government of Unionists in Wheeling, West Virginia, but I'm always interested in the fact, like, how could they get away with letting West Virginia secede from Virginia if they were still trying to maintain this idea of that we still respect this, sort of respect the state government, sort of. Not really, but the ones at least that didn't rebel against us. But I think that's the question: is like how, and I think also, we were still dealing in states like Tennessee that were a majority of Union hands for a good portion of the war. Were there similar type relations with the state governments there too, as far as during the course of the war itself?
A lot of great questions. Can I start? And if you want to pick up, very interesting area. A lot of times we forget West Virginia was created during the Civil War. And what the North did is they convened obviously the West Virginia mountain people, not slave owning, they were not so excited about secession. So the North convened the Virginia legislature. I guess in West Virginia, it just so happens a lot of them didn't go. And whoever went voted to allow West Virginia to secede, the Constitution saying, no state can be divided up without the approval of the state. I think that's kind of war-based. My own, and this is not a legal take, but one of my favorite quotes, anecdotes is, it happened I think at least twice, but anyway, after Gettysburg, right nearby, Meade reports to Lincoln, don't worry, we have now driven the enemy out of our territory. And Lincoln responds saying, wait a minute, it's all our territory. I wanted you to destroy that army. It was north of Potomac. I don't want to hear this stuff about you driven them out of our territory. But anyway.
Well, that's why when I saw the judge's map of the Confederate States of America and the United States of America, Lincoln would have been horrified by that. He would have hated that conflict. Builder's Point's a good one over there. So the judge talked about this American tradition of pragmatism. The West Virginia case is a classic representation of that, because literally when Lincoln signs this measure into law, West Virginia statehood, he says, this is not a precedent for the future. Understanding, as the judge put it, it was a wartime measure that wasn't really constitutional, but they were going to shrug their shoulders because they needed it. Almost in a sense, in the same way they packed the court and expanded it to 10 justices, as he pointed out, because they needed the votes. So pragmatism is a great American tradition too, and I think sometimes we need to celebrate it. But in that spirit, let's celebrate the judge's presentation one more time.